All right.
Hi, good morning. It is January 31st in Senate Judiciary. We are doing our first markup of S12. This won't be the last time either. This is our first time going through this bill and making some changes, stressing some decision points that we've highlighted over the last 2 weeks or so. And we're going to continue working on this bill over the coming weeks as well. And I believe the first thing that we are in agreement on as a committee, anyone can correct me if I'm wrong, relates to the licensing and access that OPR may or may not have, or potential employers may or may not have for sealed records. And my understanding is we are going to change what's in this draft, essentially just to make whatever the new system is similar or identical to what the current system is in regards to licensing and what type of access people have or don't have. Is that
Because right now
right?
they don't have.
Right. So that's my long-winded way of saying nobody's going to have access. We're not changing anything regarding that.
So right now they don't have access.
Correct.
And we're not gonna in the future allow that access for OPR.
Yeah.
Okay.
And my perspective on this is, the whole purpose of this concept of sealing / expungement is to, after 10 to 15 years of somebody not getting in trouble and not having any issues, and they seal their record and they're trying to get employment or get licensure to start a business. It's this idea of giving people a second chance to get gainful employment. So, that's my perspective on it. Committee, any thoughts? Does that sound part of this?
I agree.
Now, is there any professions that we would worry about, certain crimes that get sealed that are part of this bill that we'd want to know about? That's something that happened in their past?
I know law enforcement will still have access.
They'll still have access.
Yeah. And but beside that, that's more or less it. It's with the current system, I haven't heard.
Yeah,
It's not like the sky is falling.
yeah, that's the other thing I was gonna say. I haven't heard it of being an issue.
Senator Wilson.
I will say that we do license, and I say this as a licensed social worker, we do license professionals that deal with vulnerable populations, and the types of crimes we might want to know about are, 1, not expungible, and 2, would put you on an abuse registry. And so, and those things won't be impacted by this at all.
Cool.
So I do recognize, your point that there are places where we license people who we would want to know certain things,
Yeah.
but this bill doesn't take away our ability to know those things.
And just to expand on that. So to me, it's always seemed like the work we did creating the list of expungible crimes takes into account this consideration that. So there were lots of things we didn't include because, somebody was a danger to children or sexual assault person. And so having made those decisions, I'm very comfortable with taking that up. So
Great.
That's what I was just gonna say, is to build on what the two of you had said, which is that you have to always go back to the qualifying offenses there and keep that in mind in the sense of and maybe we just do this as we start to do like a walkthrough, is just like kind of looking at those things as a reminder of the things that have been excluded as eligible for sealing. Because I think those are really the offenses oftentimes that they're looking for in terms of licensing.
And perhaps I'm jumping ahead, but in this draft, are we adding any new offenses that are eligible for sealing?
Yes, you're adding a lot.
Okay.
And that's a point. And so, forgive me because I don't recall, because so much has happened over the last several years on sealing, but there've been a number of studies and recommendations and things like that. And this list has been in legislation for at least a couple years, you know, maybe some small tweaks and things like that, but my recollection is that it came from study group or something, you know what I mean? So it's like, it was kind of vetted, because oftentimes when you're dealing with lists, right, when you're trying to come up with a new list, violent events or things like that, those are how you've got to look at each event and kind of make a determination. And so that kind of work had been done to intentionally exclude, you know, those like violent crimes, person to person offenses. You know, there's no sex offenses on this list. You know, things like child endangerment, things like that are all excluded from eligibility.
But they're being added in this?
No,
No, they're not, but can we go?
Yeah, that would probably
be
be
helpful, is
best.
to just look at the list. So if we're looking at the bills introduced and we look at page 4. So remember the way that this works, and if you still have your little sheets that I gave you before about this, a summary, you know, the easy thing to think about what works and what's going to be eligible here is that a qualifying crime is all misdemeanors except this list that you have starting on line 11 on page 4. So no listed crimes, you know, no sex offenses, violation of protection orders would be excluded, abuse, neglect, or exploitation of vulnerable adult. And then you see, you know, the list continuing on through page 5, failure to comply with the sex offender registry, cruelty to animals, cruelty to a child. So these would all not be eligible, right? Then if you look at page 6, and then it's the opposite for felonies. So misdemeanors, it's everything except the list, and for felonies, it's no felonies except the ones that are specifically identified here. They typically fall into the category of designated felony property offenses and drug offenses. I do note that on page 6, under the definition of designated felony property offense, Judge Zone had noted yesterday in his testimony that first one on a felony violation for fraudulent use of a credit card, that's not a felony. So I really appreciate that, because this list, like I said, I think was recommended to the legislature and it's been used. And I had, you know, I guess I didn't go through and check that at the time. I thought I had. And so we're going to take out that 5A because that is not a felony offense. There's no, if you look it up, it's a misdemeanor. So again, the felonies are related to the theft.
Yeah. Yeah, I was about to mention, it seems like every one of these offenses is a property offense and does not involve an act of violence.
Correct.
For its victim. Senator Wilson.
Michelle, I realize I may be asking a question that you can't answer right on the spot, but do we have other non-violent felonies that are not property crime, or is that really the only spot where we have?
Oh, I'm sure. Yes.
Okay. I'd be curious to know what that list might be. And again, I don't expect you to produce it on the spot from memory, because
Right. No, I mean, that would have to be something that we'd have to reach out to the crime research group for a list of felonies and then literally just kind of start to scan through them.
I am interested in what's on this list in terms of misdemeanors and felonies, but I'm also interested in what's not on the list and whether, and I know, as you said, this has been sort of suggested for many years.
Right. And I'm sorry, it's like, when Bren was part of our judiciary team, she had been doing all the sealing work. And so when she left the office briefly, then I picked it up, kind of just inherited some of the things that had been, the work that had been done. But I can try to go back and look and see kind of the genesis of this original list and where that came from, and the sentencing commission.
Yes.
I feel like it was the sentencing commission, but
yeah, that's my memory, is that Senator Sears moved it to them. they came back with a list and then that list.
Right, so I can probably pull it up and, I probably wrote a report explaining that it came from the Sentencing Commission and then had forgotten that. They were always joking about like, once we hit a certain mark in this job, we need the two of us for our combined memories on some of these things when we've worked on the same issues, so many years. So is everybody okay, comfortable with the list for now, just in terms of understanding what's there? So substantively, so there's a lot struck. And, so if we go to page 15 is where they start for the process. And you'll recall that, the process, is, so if you see starting on line 7, so someone has to petition. So we're not talking about automatic sealing here. So somebody would have to petition the court. And there's 2 circumstances. One is, that they were convicted of offense for which the underlying conduct was no longer prohibited. Cannabis is a perfect example of that, although those are, you can do that now. And then remember a few years ago when you adopted the commercial system for cannabis, you ordered actually the automatic sealing of all of those misdemeanor offenses. For things that would fit under what would be legal now, so that people didn't have to do that. I mean, the court completed that work. I think it was a little bit delayed because of COVID, but that work is all done. And, but that's an example of that type of thing. And then the other one is if it's a qualifying crime. Subdivision 2 is just a reminder that it's whichever office prosecuted the offense is the one that is the respondent in the case. So if the state's attorney that prosecuted the misdemeanor, then they would be the ones that would be a party here. And if it was the AG's office, it would be the AG's office, but they can defer to the other prosecutorial office if they would. So that's up to them.
Michelle,
Yep.
I was wondering on those automatic sealing offenses, if that lessens the burden on the court systems, and if so, are there any other offenses that we could possibly put in there to have automatic sealing?
Well, that actually, so if you recall last year when this big bill came over from the House and this committee wound up not proceeding with the substantive language and directed the court to essentially report back to you on petitionless sealing. And so you do have that available here. And so you might want to, in just the context of all of this, I don't know, but while you have this as a vehicle, you might want to ask Judge Soni to come in and talk to you a little bit about that report. So you can kind of understand what would be needed to move forward on doing any kind of petitionless sealing. I mean, I think the short answer is that some money and some time. You know, the technology, they're not set up structurally and don't have the technology to be able to do that. But there is a report that you have and Caleb can send to you. It's on our webpage.
Yeah, I was wondering about that as well. Perhaps doing endless sealing for misdemeanor offenses. That could be a possibility, but Senator Rhodes.
Yeah, my understanding from a couple of conversations with both the courts and the Department of State's attorneys and sheriffs over the last couple of years is the automatic portion of that is somewhat of a misnomer. It is not that it instantly happens. There's still all the background work that has to happen.
Right, we changed the name actually to stop saying automatic sealing to petitionless sealing.
Yeah.
Because for that exact reason. So.
There is one piece that I'd like to add. It's a small thing. Open to hearing suggestions, but I would like to prohibit having sealing not be allowed in plea agreements. So right now, there are circumstances in which a plea agreement can say the defendant can never have their record sealed or expunged, and it's being put in some pleas as a condition for that plea agreement. I would like to prohibit that. I don't think that it's. I think that it defeats the purpose of what we're trying to do here.
Can you give me an example of that?
Yeah. So if, let's just say hypothetically, I have a client who was charged with disorderly conduct. And, we come to a resolution with the prosecutor says, okay, $200 fine and 6 months of probation or something along those lines. And the defendant can never petition to have their records sealed or expunged. And the defendant signs and agrees to that. They can then never have their record sealed or expunged.
For that particular case.
Yes,
Well, why would they want to do that?
I don't know. It's a common question among defense attorneys. It's one that I have. I think, I'm also speculating, and this is something that perhaps Tim LD can raise, but perhaps it's because of the current system in that the records are completely destroyed and they're accessed again. And so the state's attorney is perhaps taking a sort of precautionary measure to say, we don't want those records destroyed ever. So we're going to say in this plea agreement that they can never be expunged. And that's, again, I'm not speaking for the state's attorneys. That's my own theory as to why this.
Yeah, and I would support that. Because it's really the state's attorney doing a kind of end run around the legislature at that point. Because we've said these offenses can be expunged.
Yeah.
And they're taking the opportunity to add to the plea agreement.
That it can't be.
Right. To what end, since the legislature's already determined that policy. So.
Well, and I agree with your comment in theory, but that's what I'd like to hear from the state's attorneys as to if there may be a reason for this. I don't know. But if in fact you're correct in your assumption on this, then
and correct me if I'm wrong. Even in the current process, the state's attorney can still weigh in and say the interest of justice will demand that it not be sealed, right?
Yeah, the petition is final and you have the hearing as to whether or not the charge or the conviction will be expunged.
Yeah.
The state's attorney can make their argument as to why or why not.
Yeah, so even if we prohibited that in a plea deal, they still have an opportunity at some point in a specific fact pattern to make the argument that this is different. We need to prevent this person from seeing.
Yeah.
But it's not saying going forward, we expect you to not, like, it's actually looking at what has happened, not making an assumption as to what will happen.
Yeah, it's weird in several ways.
Yes, it is really bizarre.
So I will note that, and I'm sure you guys are gonna hear from Tim. It's possible, aside from the understanding reasons why they put that in there, but I would just say they may have an issue around having a statutory restriction on
Sure.
on their power to negotiate a plea agreement, but I'll let him make that case.
Yeah, and I wouldn't be surprised if it really is just related to how our current system is situated. So, but again, I'll let Tim and other state's attorneys speak to that. So.
Okay. So still on page 15, bottom of the page, subdivision 3 is that basically if the state and the petitioner stipulate to it and everybody is in agreement, then the court doesn't need to hold a hearing on it. As long as the person meets the requirements. So page 16, just there's that note on subdivision 4 with regard to the CDL licenses. And, my recollection was, these were things that were asked by the legislature from DMV because of certain federal requirements and being able to, and having to comply with federal law around background checks for folks who are driving big rigs. And so then you get down to, remember, it's organized according to the types of offenses and in terms of how long you have to wait and what are the conditions for sealing. So the first ones are offenses that are no longer prohibited by law.
Sorry,
So
which page and line?
so you're on page 16, subsection B.
Oh, yeah.
So if it's no longer prohibited by law, then there's no waiting period at all. And I know Senator Vihosky said that you had an issue around the completion of sentence or supervision, like those kinds of issues, restitution. So I just note that, but this has again been previous versions. But there's no way, so you could do that at any.
Yeah,
Did you have questions?
well, so I don't know that it's a question so much as a comment, but or a couple of comments around the section. So my concerns with this section are, one, I think it should be exceptionless. I don't think it should be on the person to know that we've changed the law. Two, I think that it should be that sort of what we've discussed as the super ceiling, where the only person that can see it is the quote unquote petitioner, although now they would no longer be the petitioner because I'm suggesting it be petitionless. Those might be my things.
But I think, with regard to the petition list, the issue again is, logistically, I don't know about entities' ability to be able to do that in terms of notice. So if something is known, so if the law changes here, then how does the court know necessarily and then identify those folks and then do all that? And it maybe it's possible, but maybe that's something you can raise with Judge Zone, if you happen to talk about that study.
I think also one thing I'm noticing is that there isn't an opportunity for the state to oppose it, which I think is perhaps the closest we could get to petitionless, because I'm seeing that it's a shall grant the petition, so long as the two conditions below are met.
Shall do you have a recollection of what we did with cannabis? Wasn't that petition list?
That was right.
Okay, so we already have I don't know if framework is the word that I want, but we already have precedent for saying, hey, this is no longer a crime. We're just going to get rid of it. We're not actually going to ask you, the person, to be tracking state law to ask us to get rid. So I'd be curious to know, and I know it took a long time. I know we worked on some stuff that we had to kind of look into, but I'd be curious to know what that was like and how that works, given that we have a precedent for making it petitionless.
Yeah, and I can't see it as being, with cannabis, it was a very broad, sweeping change that decriminalized, that decriminalized a lot of prior convictions. And so I can see how that may have taken a long time. But I don't suspect, something similar is going to happen in the near future. But yeah.
So I will just note on that, something to think about is, so with cannabis, we're kind of laser focused on this one particular provision in law, which was this, what you legalized was a possession of an ounce or less, right? There was a complication there in the sense that the old statute for misdemeanor possession was 2 or less. And I remember you were, really instrumental in when we were talking about all this, is because the issue was like, well, how do you figure out if somebody has let's say if the citation was 4230 subdivision A1, right? And it was 2 ounces or less, and somebody has a conviction. Or let's say there's, 5,000 people that have convictions for that. How do you know out of that 5,000, how many had an ounce or less, right? Or above? And what the legislature decided to do was say, well, you know what? That's impossible for us to really know unless somebody goes and digs in, sees if there's an affidavit in there saying what the amount was, things like that. And that's going to overwhelm everybody. And so you just said, if you have, as of this date of legalization, if you have a prior conviction for this, we're going to ask the court to get rid of your record. But that was on this really, just say this particular offense. I would look at this issue and just saying, if something's no longer offense, there could be something that you guys decriminalized or turned into like a minor civil ticket or something like that 5 years ago, but somebody has a 15-year-old conviction for something. I don't necessarily know that we have some kind of inventory on what we have decriminalized over the last couple decades or something, and to know what that would be, to be able to specifically direct the court to identify what those offenses were and then find those records.
And the other thing about the backlog that strikes me is, by doing this, this bill, assuming we can get a compromise that everybody's happy with, it will reduce the workload on the system, and theoretically it will contribute to, less bureaucratic, person hours being consumed by this. So I would want to make sure that we didn't inadvertently add, because you mentioned that the work had been done on cannabis offenses, but that it took 5 years or.
It was a lot of work, and I can go back and look, because somebody did inquire actually just a few months ago about doing that. And I said, oh, actually, it's already been done. And I asked Judge Zone for information, and he gave me the dates of when it was completed and how many records were.
So anyway, just so that we have in our mind what we're doing all the time to the workload of the judiciary. Yeah.
Well, I appreciate that. And, I also take your point that theoretically, these things, should maybe not instantaneously, but over time decrease that workload. The concern that I have is I know that we all in this room find our work to be very important, but, Joe, layperson, is not paying attention to every little thing we're doing in here. And if they happen to be actively being harmed by a record that is something we make no longer a crime, I don't think that it is fair to put that on them.
Yeah.
And so I think that much like we did in cannabis, we could give the courts time to deal with anything past. And going forward, hopefully we would have in our minds, if we decriminalize something, that we sort of explicitly name, like the court shall expunge this list of stuff, or seal, as the case may be. I don't want someone, simply because they don't have the time to pay attention to everything we're doing, to continue to carry around that record because they didn't know they had to petition for it, when the person who did that exact same thing today would never have a record.
Well, we are going to have, at the end of the day, we will have a category of things that people have to petition for. I don't think it can all be petitionless.
No, I'm just suggesting that if it's no longer a crime, it should be petitionless.
Yeah. And it's a balance.
So I was just looking up on the old email. So you had passed that legislation. Remember that legislation passed when we had that session that went to October. And you passed it in October of 2020. So we're right in the middle of COVID there. And so according to the court, between January 2022 and September 2023, 12,948 expungement orders were issued for misdemeanor cannabis.
12,000.
Just under 13,000, yeah, 12,948.
Okay.
So a lot,
Yeah.
a lot of work. So
I don't know that we're in the habit generally of decriminalizing massive amounts of things or making previous crimes not, like, that's something we do.
well, I would say,
frequently.
and I don't know, and if a record's so old, maybe it doesn't. I think when the Attorney General was talking, she was saying, it was hard finding somebody's old record, but it was still out there somewhere. Is that, you remember when when the legislature created the Judicial Bureau, right? And expanded that. So you didn't just have traffic court, but you have Judicial Bureau. And then there was a number of years there where there was kind of a lot of shifting of criminal statutes, maybe minor misdemeanors, but that would go through criminal division and potentially result in a criminal record that were shifted over to the Judicial Bureau. So
I think one of the most prominent one was the DLS, right? Operating after civil suspension.
oh God, yeah, I don't even know where that is right now, but I know.
It's a moving target.
Yeah. I know I personally, even though I don't typically work on those driving issues, but in my career, decriminalized it and criminalized it a couple times just myself. And I'm sure Eric probably, went back and forth, how many do you get? And, stuff like that. So, but. Is it okay to keep going?
Yes.
Okay, so the next one on subsection C, page 16 is the qualifying misdemeanors. So for that, the requirement is that you wait 3 years. So remember, the formula is sentence plus, whatever the waiting period is. And then whatever you decide in terms of access for sealing. So right now in the bill, with the super sealing for the 10 years. So for a misdemeanor, let's say someone was 2 years probation, they complete that, they wait 3 years. So then you're at 5 years from conviction to be able to petition, and then access to the sealed record for another 10. So from date of conviction, law enforcement could see that sealed record for the misdemeanor for 15 years.
If I can add, I know we haven't heard from Jeff Wallen yet, but from my understanding, I think that the issue of whether or not law enforcement can access something after 10 years is going to be, unfortunately, a technologically challenged issue. And I think that we're going to have to come to a decision point as to whether or not law enforcement can just have access indefinitely after something is sealed, or if they can't have access at all indefinitely after something is sealed. And I think that with whatever path we take on that, there's going to have to be some give and take on, I'm thinking perhaps the amount of time in which somebody has to wait until they can petition, or perhaps what offenses are eligible for that. And so that's just something to keep in mind. And I think that once we get some more answers from the Crime Information Center, definitive answers, then we can figure out how to proceed. But I think that is probably going to be the big decision point for the committee as to how we're going to manage that.
So I will just note that on this one, so on the, you see on the language in C1, 3 years have elapsed since the date the person completed the terms. Judge Zoni had raised the issue of whether or not you wanted to add it successfully or not.
I didn't really understand the difference.
I
mean,
I think that either way, whether you have successfully or not, the court is going to be making,
right.
A judgment there. I mean, I'm based,
But, successfully completed to be.
Right.
Meaning completed the requirements, not how well or how.
Right.
So,
I don't personally have a concern about that. I just wanted to raise it because it was mentioned yesterday and I
Yeah,
didn't know whether folks, wanted to change that or.
Yeah, no, I agree with Senator Baruch that as far as I see it, it's sort of 6 of one, half dozen of the other. Like if they've completed it, the time starts ticking and the judge and the prosecutor still have the ability to say, no, this person messed up 57 times, they shouldn't have it expunged. So to me, the clock should start ticking when it's completed, period. And then they can petition for it. Maybe they get it, maybe they don't.
Right, because I don't see any reason why you still couldn't consider that in the context of the third requirement, which is sealing would be, contrary. So like the state's attorney could say, well, yes, they did their term of 2 years of probation. However, they've had these, 4 or 5 violations. And therefore, we don't think that it would be in the interest of justice to have the record sealed. So I think you kind of capture that in subdivision 3, which is part of each one.
Regarding that, so if somebody, let's say there's, we're talking about qualifying felony offenses, and you have that 7-year time frame, and somebody gets another conviction, let's say a misdemeanor, in year 3, they can still petition to have their felony sealed successfully.
Well, that's one of your decision points. And so that goes to this issue on page 21 on 7604 on the new charge. And which currently says that for a petition for expungement, the court can't act on it if you have a pending criminal charge. And then the question was, well, should that have really been changed to sealing? And that's just a policy decision for you. or it could be sealing and expungement, depends on if you leave any expungement existing, like for the 18 to 21-year-olds. So that's one of the big decisions for you, is that if someone has a pending charge, then should they be able to still petition if they otherwise meet the timeline? And then the court just considers the fact that they have a pending charge as part of does it serve the interests of justice or not?
I think, my thought on this is, one, I think we should replace the word expungement with sealing, because at this moment, it appears we're moving to a sealing system.
Mm-hmm.
My question though, or my thought is, we are adding more offenses that are eligible for sealing. And there is, well, how do I phrase this? I think that if we're, following this idea that if somebody doesn't commit an offense and is not convicted of an offense over the course of 7 years, plus the however many years for probation, and there's nothing on their record, then it makes sense that they can move forward with sealing. But if you have not just charges but actual convictions in that timeline, then there is a higher risk of recidivism. And I think that if you have convictions during that 7-year time period, then I think there's an argument there that you can't petition to have that old charge sealed. But I think that's the balance between adding additional felonies that can be charged versus under what circumstances somebody can petition.
So right now it's just around directing the court to not take action on the petition if there's a pending charge. If you want to say that you are not eligible to petition if you've gotten a conviction for an offense during that pendency time, then we would have to add that, and you'd have to make the decision around how would you then toll it going forward, right? And then also what offenses. So let's say you you're looking to seal an old property felony, right? And you pick up a misdemeanor shotgun. Should that, you know what I'm saying? Like, what is the level of offense that kicks you out and starts the clock tolling again? And then when does that clock start tolling? Like, so that it doesn't, so for that old conviction, you know what I'm saying? I'm trying to, like, when do you still want to make them eligible at some point, right?
Yeah.
So how do you go back and do that?
Yeah, I'm of the mind to keeping that conviction prohibition exclusive to felonies at this point. It is easy for somebody to, get a disorderly conduct and then why.
So if you get a conviction for a felony, no matter what the stealing offense is.
My mind is, my thought is, you get convicted of a property felony offense. 3 or 4 years later, you're convicted of another felony offense. That first felony offense, I don't think it should be sealable until 7 years have passed after the second one. Because we're talking about a completely different.
What if it was a misdemeanor that you're looking to have sealed and you pick up a felony?
I think maybe. Yeah, I think maybe
Says it all right here, huh? Let's just stop right there, Michelle.
Okay, so it wouldn't matter what offense you're looking to seal. If you pick up a felony, that starts the clock ticking again on the
I think that
whole
given
offense.
the severity of felonies and given that, multiple years have passed and you're convicted of a felony, there's a question there as to whether or not, more felonies are going to be committed or misdemeanors are going to be committed in the future, and whether or not that prior misdemeanor should be sealed. But you know, if you get convicted of 2 misdemeanors in a year, or even, you know, 2 or 3 years, I think you can petition to have those sealed in that timeline. Senator Host.
So my question about this sort of idea of adding in this piece is, are they then sort of linked together? So I committed a felony. Well, maybe I won't commit the felony. Maybe Senator Norris will. Someone commits a felony, you know, 4 years later, throws brick through the $2,000 window. That's felony because it's not a $900 or an $899 window. And then go, you know, a year later, picks up a DUI, and then goes 7 years. Do they have to make 3 petitions for all of those? Or can they somehow, do you see like the problem it creates of like, okay, well, it's been 7 years from this, like it just creates kind of a mess.
I'd like to avoid creating a mess. I mean, feel like if the offenses are all eligible for sealing, they should all be included on the same.
So they can be petitioned together.
I think that should be,
Okay.
that makes sense instead of having 3 separate hearings.
No, I agree with the conviction portion, but what about if someone is pending a criminal charge, it stops at this point?
Yes.
I think, yeah, we already have that one.
Right.
Right, and I think what I'll do,
It doesn't matter, it's misdemeanor or felony.
Right.
and it depends on where you decide to go, whether or not expungement is absolutely completely gone from the system. But for if there's a new charge pending, I think I would just say add sealing to this one, the existing law on expungement. So if there's a petition for expungement or sealing, then you can't, the court is to wait and not act on the petition.
Now, if that pending charge were dismissed, it would not.
Then, yeah,
It could proceed as,
Yeah.
okay.
Good stuff.
okay. All right, so for now, and I realize that depending on where you decide to go on the length of access after it's sealed, these may change, but you guys are good with the misdemeanors and the 3 years for the misdemeanors and the 7 years for the felonies in terms of
Yeah.
time?
Good on those for now.
Okay.
They might be revisited.
And then, bottom of the page on subsection D, it's 10 years for qualifying DUI. And then remember that DUIs can still be used as predicate offenses for subsequent DUI. So even if you let's say you have a misdemeanor DUI, it's 2 years. Then you wait 10 years, so that's 12 years. Then it's sealed. If you pick up another DUI, they can still look. You're right, in terms of like determining that you have a prior DUI, so it would be a DUI 2 instead of a first DUI. Unless the DUI plus, I don't know, if they ever roll off and start over again after a certain number of years or.
Senator Host.
I think so, and I think that's what we're sort of contemplating here, but my question is if there is any data or evidence that shows that so we're using data and evidence to say, like, after this period of time, someone's less likely to recidivate, but we've decided for DUIs, it's going to be a longer period of time. And I'm wondering if there's evidence that people are more likely to commit a second DUI for a longer period of time. I'm just wondering how that landed on, and I'm looking both to you as the attorney that may have information and to you as the attorney that has dealt with this for a while, and maybe neither of you.
I don't, because I don't staff DUI, but I mean, I do recall that it was a shorter period a couple of years ago, and there were a lot of people and organizations who were upset with that, and so it got extended to 10.
All I can remember is, I think when I was in the house and we were talking about that, I was shocked at how much, at how complicated and frankly convoluted it became when we were talking about predicate offenses and how to incorporate them or not incorporate them into this. So that's all to say, I don't know the exact answer, just that it was extremely complicated and very long conversation.
Yeah, I'm curious if there is someone in the world, and maybe it's the crime research group, that can actually lay out the sort of data behind when that recidivism point drops, because we know what it is. You know, that after X number of years, people are no more likely to commit this crime than someone who's never committed this crime. But I'm curious if for DUIs that is somehow different. And I just want to make sure that whatever we're doing is data driven and not just driven
Yeah.
because someone's angry or we're like, yeah.
Okay, keep going.
Yes, please.
So bottom of page 18, subsection F is something that was asked for by Fish and Wildlife, but they just wanted to make sure that, if somebody had something sealed and somebody's, let's say you had accumulated a certain number of points because of certain offenses and you had your license suspended or revoked, that if you later got something sealed, that it wasn't gonna undo your revocation or your points.
Senator Rose?
This may be a question for, I think Damien is doing transportation now, but how long do points sit on a license?
No.
Because
So this was with
These are-
Fish and, this is
these are
Fish and Wildlife, not driving,
oh, okay,
Fish and Wildlife.
okay,
And
Although-
I believe it's 3 years.
3 years, although it is a little bit relevant to the previous conversation around like other driving offenses. So we say 3 years and the driving offenses go away. So I'm just, thank you. I appreciate that. But
Fish and Wildlife has a cumulative type point system as far as the tickets are concerned. So you may get 2 tickets for the fishing without a license, 2 points for fishing without a license. And with a certain period of time, if you accumulate 10 points, you'll have a revocation of your license. But the major crimes, what they refer to as major crimes, mid-game, out of season, possession, and so forth. But most of their offenses are ticketable offenses.
Gotcha.
9 out of 10 are ticketable.
which is the same system we have for driving licenses, yes? You have a period of time in which if you give like 10 points, your license is suspended?
Yes.
Oh.
As far as I can remember.
Right, but I think what Bob was saying, which is true, is that, you know, those fish and game offenses, which used to be criminal, you know, shifted over to the Judicial Bureau, are
Okay.
civil
They're civil.
offenses.
Thank
You know
you.
what I mean? So it's not like so these things like fishing out of sea, you know, whatever those things are, and I don't know anything about those
Citable
laws,
offenses are still crimes for Fish and Wildlife, but the majority of their crimes
or just a ticket.
Are
are
civil,
civil.
and therefore they do this point process, much like our driver's license. Thank you for helping me navigate. I'm not a
Yep.
expert in fish and wildlife laws.
So page 19, this is, if there are circumstances where there's no conviction. So if you look at subsection A, these are circumstances where you have person, you know, probable cause isn't found at arraignment, charges dismissed before trial, either with or without prejudice. Defendant is acquitted of the charges. Or at any time, the prosecuting attorney and the defendant stipulate that the court can grant the petition to seal the record.
Senator Rose?
Can I just ask a clarifying question? Because I'm not a lawyer, but what is the difference between a dismissal with prejudice or without prejudice? What does that mean?
It's with, I'm sorry.
Oh, I'm sorry.
No, you go right ahead.
With prejudice means it's dismissed based on the merits. Without prejudice, without the merits. So in other words, something is getting dismissed because of if it's dismissed with prejudice, it's because of maybe there wasn't enough evidence or didn't meet a certain threshold. Without prejudice is perhaps a technicality, and you can bring the case back.
Got it. Okay.
That's the big distinction that you want to think about. If it's with prejudice, they can't come back and file again.
They didn't
They
meet
can't,
the standard you have been said.
right,
You didn't do it.
You cannot come back and
Got
file
it.
again, done. If it's without prejudice, they can go back to the drawing board and come back and refile.
Okay, thanks.
So top of page 21, this is on the new charge, so I think based on what you're talking about, so I'm gonna add this so that it's gonna be, if there's a sealing or expungement petition and there's a pending criminal charge, and the court's not to act on that until that case is resolved. This issue around if you have a conviction, for a felony during your waiting period, I'm gonna incorporate that into those little those subsections on what the criteria is to petition, so that'll go there, but it's just related to that, so I'll just mention that.
It's a quick question. What was your suggestion that upon a second conviction of a felony, that they'll never be able to seal the records, or the time starts
But
all
the
over
time
again?
starts all over again.
But that they may petition for all on one petition once they've gone
Yeah.
a required amount of time with no conviction.
Yeah, so felony 1 happens, 4 years later, felony 2 happens. And then 7 years after felony 2, they can make a petition to seal both felony
Right.
1 and felony 2 at the same time.
But, so what if the first was a misdemeanor? And
Yeah,
then
that's
during
yeah,
the
I mean,
2
I'm
years,
thinking-
there was a felony.
right. I mean, I'm thinking off the top of my head.
Yeah, I feel like we should stick with the same things.
Yeah.
No, whether it's a misdemeanor or not, the first offense.
Mhm. If it's a felony,
If
then
you
you
have
have
a
to
felony
wait.
pending,
Mm.
I don't even think it should be a conviction. I think if you have a felony pending,
Well, I don't know. I mean, I feel like having a conviction is even worse because I mean,
Yeah.
the pending felony hasn't been proven. And so if, you have you know what I'm saying?
yeah, sure. I'm just thinking, what is, it's based on the idea that somebody has a clean record and they should be able to expunge. If they have a felony, pending, let's say it takes 5 years for that to get adjudicated. I would hate to have the system working on expunging their past efforts and then they get convicted on the felony.
Well, you guys already took care of that here.
Oh, we
If
did.
it's pending,
Mhm.
then court is not to take any action
Yeah,
on sealing
that's what I'm
or
saying.
expungement.
Yeah.
I was just clarifying because if you're talking about that you have a conviction, does that restart the clock?
And that's what Donna's saying.
Yeah.
Is it restarts the clock, whether the first offense was a misdemeanor or a felony?
But
Yeah.
just to clarify, while it's pending, they can't move forward. on it.
Exactly.
Course game before.
Yep.
So how many, just hypothetical situation, so how many felonies are we gonna allow an individual before we say you can't city records? As long as you do that as the second one now.
Well, I think that's where you're gonna get into this, the respondent, state's attorney, or whomever is gonna say, this is, not in the interest of justice. This person's look at this person's record.
Well, you would hope so, but that they bring that up, but I'm just saying. And I'm asking everyone's opinion, should we or should we not? I said, okay, upon conviction of a felony, you just can't have the records sealed or from this point forward. And that's like 21, 7, they could be like 21 years later, right? I mean, after 3, you're still making felony offenses. I mean,
Seems like that person is unlikely to push for C.
And I think it's also unlikely a judge would grant it if the state's making the argument that, this person has 12 felony, 6 felony charges pending, 6 felony convictions in their past, and I feel like the state could make a reasonable argument there.
well, I just want to make sure that we don't get confused with intent versus statute here. Then somebody has to figure it out 20 years down the road.
Yeah, I would want to leave that up to the discretion of the court, because I could imagine another instance where, say a 21-year-old picked up, 3 or 4 felonies at the same time, because they were involved in, I don't know, I can't think of anything at the moment, but now has gone, 15 years without doing anything. And so I don't think that we can, in this room, by statute, navigate every possible circumstance. And I want to trust the judicial discretion that they'd be able to look at the case you're talking about and say, this is not in the interest of justice, but look at another case and say, we see that was, a young person who made a big mistake, but has now really gone on the straight and narrow, put their life together. And it is in the interest of justice. But the numerical value in those two instances may be the same.
Mhm.
That's all.
I'm still processing.
Okay, I'm gonna skip down to page 23, bottom of page 7607, which is the effect of ceilings. And so this gets into the tough stuff, right? So if you start at like page 24, sets forth the process for sending the ceiling orders out. If you look at page 25, subsection C, these are the exceptions. So on line 15, this is where you have the access for 10 years. And then let me just walk through the exceptions for you and then have at it. So the first one is subdivision 1 is that any entity or person that comes up with a sealed record may continue to use it for any litigation or claim arising out of the same incident or occurrence. So as you can see, that's current law.
Michelle, I'm sorry, I apologize. Can we go back to the bottom of page 24?
Sure.
Because our discussion about OPR, it seems, unless I'm reading it wrong, is sort of mooted by this subsection 2 at the bottom, line 19 and 20. Where it says many application for employment license or civil right of privilege, blah, blah, blah. Person may be required to answer questions about previous criminal history record only with respect to arrests or convictions that have not been sealed. So we're moving down the track there of saying when you go for a license, that's not to be a subject that the person has to answer to. So the OBR section seems to me to conflict with that.
Mm-hmm.
So since we're removing it, it seems like we're in line with where the bill was going up.
I think you're correct. That's current law.
Okay,
Yep.
good.
Mm-hmm. So moving on to top of page 26, subdivision 2. And that's, you'll see existing law, which is the criminal justice agency. And then we added the attorney general because they are not considered a criminal justice agency. I think it's like 51% of your resources and such has to be for criminal justice purposes. And because they have a large civil division or anything, they did qualify. So we added them. So that's your law enforcement access. Subdivision 3 is the using it for predicate offense for DUI. Subdivision 4, person or court in possession of an order can cite to that decision in any subsequent proceeding and ensure that the identity of the defendant and the sealed record is redacted. My recollection was, I can't remember, maybe it was like state's attorneys that originally brought that up around, and there were certain circumstances where they wanted to cite something as precedent, but then the record was subsequently sealed.
Yeah, it's an issue among defenders as well.
Right.
Yeah.
Yep. So subdivision 5, Center for Crime Information, the BCIC and Criminal Justice Information Services Division of the FBI has access to sealed criminal records without limitation for the purpose of responding to firearm background checks. Subdivision 6, this is on the discovery. And I made some notes there about Judge Zone's comments around, instead of a may, shall, which is an appropriate comment, disclose information contained in the sealed criminal history record when required to meet discovery obligations. Page 27, top of the page, subdivision 7. So someone who, if it's your record, you and your attorney can have access to that record in perpetuity without any kind of limitation. So there's no restrictions on you accessing your own record once it's sealed. Subdivision 8, law enforcement can inspect and receive copies of records of any applicant who applies to the agency to be a law enforcement officer or a current employee for the purpose of internal investigations. Um, 9 has to do with research. So crime research group and such, they can have access to all those records.
In this next section is where.
Right, and then the 10, 11, and 12 are the ones around licensing.
And just to explain what seems odd to me here. So we pass laws all the time, rules get propagated based on what we put into statute. And then LCAR is a check on whether those rules mesh with legislative intent. And then they can file objections. And that doesn't end the process, right? There's further action. But here, if they object to some or all, then the whole thing is stopped. It shall not be permitted. So all they have to do is file an objection to some part of the rules and it's stopped as though that's the terminal point of action.
Right, so like
See what I'm
it's
saying?
yeah, so the idea being is that, so and as you know, like LCAR has, very narrow basis to be able to object to an
Yeah.
administrative rule. One of those being, is contrary to legislative intent.
Mhm.
But the idea is that you are granting some authority to this agency and saying, we're granting you this authority, we're delegating authority to this agency. You're
To
gonna,
LCAR.
no,
Or you mean to propagate the rule?
the legislature is saying to the agency, you can look at these sealed records. We're gonna authorize you to be able to do that. However, you have to adopt rules for how you're gonna do this, and it has to be in keeping with what we set forth.
Mhm.
If your rules, we feel as though your rules are not in accordance with our legislative intent, and we object, then you're not gonna get the gift we just gave you, which is accessing the records.
But then it doesn't speak to what the rest of the process would be.
Then I think what it would be is that they would have to come back with other rules that meet LCAR's.
Right, but it doesn't say that. It says that if they file an objection, then access shall not be permitted. It sounds to me like it just terminates at that point.
I don't think that's the intent.
Okay. Because, LCAR has disputes, not all the time, but it's not uncommon for LCAR to have a dispute with the administration, let's say, over like the trapping regulations that got put out. And LCAR objects, but that doesn't end the process. And it seems like here what we're saying is, in this particular instance, if there's an objection, not even to all the rules, but some of the rules, then access is not permitted. And
Yes.
and I don't know, that just seems, it seems like more we're giving them a veto, not that we're preserving their authority. Does that make sense? So at that
Yeah,
point,
well, I think that was the intent, is to say that you get this authority, but only if you adopt rules
yeah,
that we approve of. And if you don't adopt rules that we approve of, that are in keeping with legislative intent, then you're not we're not delegating this authority to you.
yeah,
So, I mean, I think, and I don't know, you'd have to, it's a bigger conversation for people that deal with administrative rules, which is
And-
not me,
and
and
it's moot
it's
anyway,
moot, right?
because we're pulling.
Right, so again, I would encourage you to speak with O'Grady and to Damien
Yeah, okay.
and deal with those issues, but,
Yeah,
I think the interest is that it's like, well, if this is there and you know that you have, that if you kind of come with some, I don't know, rules that really haven't reflected the intent of the legislation,
Mhm.
and is that, you may not get what you want, which is access to those records, right? So try to come forth with some rules that are going to meet with the approval of LCAR. And if and if LCAR objects, then, what happens all the time is, there's these informal dialogues all the time. I mean, I have more experience obviously with judicial rules, which is like, if, judicial rules doesn't like something, they communicate something to the court, they kind of go back and reassess, and then they
Right.
come forth with something that they think is going to meet the criteria.
Understood. I'm just wondering why in this particular instance, we're specifying a terminal outcome instead of just letting the process by which LCAR normally works play out here.
But aren't we taking it out? So it's,
We are taking it out, and this is theoretical. Michelle and I just often.
Right. It's just, the issue
Check.
was that particular case
Yeah.
was live at the time, and, House Judiciary,
They want B.
not everybody was on board with allowing this access for all these licensing purposes. And so they wanted to make sure that, the records were gonna be treated properly and, all of those kinds of things. They said, well, yes, but we want to ensure that this will be done in keeping with legislative intent of this act. And what if something happened and those rules didn't meet LCAR's standard? And they still kept doing it, and then they were seeing all these people's records, and we weren't confident that they were doing record management in a way that, was in keeping with the law.
Michelle, is this a good spot to take a 10-minute break, or are you kind of on a train of thought? Or,
No, we just finished the exception, so
oh, okay.
it's all up to you guys now to figure out what you want.
Why don't we take 10